Thank you so much, and thank you for the invitation to providing this lecture and discussion, I hope. So our topic today is delusions and criminal insanity, integrating law, medicine, and philosophy. And we are 3 researchers here working together. In addition to me, and I am a lawyer in criminal law, we have Unn Haukvik, who is a psychosis researcher and a neuroscientist, and also currently working as a clinic psychiatrist, and Susanna Radovic, who is a researcher in philosophy. The topic of the lecture is the relevance of delusions for criminal insanity, responsibility, and punishment. And we would like to enlighten this and discuss this topic from a criminal law perspective, a medical perspective, and a philosophical perspective. At the end, we will also raise the question whether we could reach maybe an integrated perspective. This figure is just to illustrate our view that working with these questions that are about how we should think of mentally ill offenders cannot be dealt with properly without including and integrating several disciplinary perspectives. And this lecture is also an attempt to show the challenges when doing this and how difficult it may be to try to work genuinely interdisciplinary. But it's also an attempt to show how the law, which is the starting point, needs to take into account perspectives also from other disciplines. So I would like to start then with the criminal law perspective before Susanna and Unn will follow up with providing an in-depth analysis of the medical and philosophical issues that I raise. When we're talking about criminal responsibility and punishment, this is, you could say, the key principle for the criminal law and the criminal justice principle, the criminal justice system, sorry. It says that only those who could and should have acted differently and therefore deserves blame are responsible and should be punished. This is a key principle in the sense that if you're not having the ability to act differently than what you did, you can never be held responsible and punished. If you crash your car because of the thunder or lightning struck it, you will not be held responsible. And in a similar way, very small children, say 4-year-olds, that hit their parents, they are of course not held responsible for violent crime and punished to prison. And then, of course, you should also deserve blame, and this is a difficult moral question that I will not go into. This is just like the entire starting point. And what we will discuss is those offenders that may not deserve punishment. And this is what criminal insanity is about. So the criminal insanity doctrine, or the legal doctrine of criminal insanity, that is, you could say, the idea, the theory of criminal insanity in the criminal law that is concretized in legal rules and practices the world over. This doctrine identifies basically those who lack criminal capacity because of mental disorder. So it basically says that some people are so ill, so they cannot act differently, or they do not deserve punishment, despite the fact that they may actually commit a crime with the intent of doing it. So this doctrine provides a general and total excuse from criminal responsibility. So that means if you're understood as criminal insane, it should not matter principally whether you commit a theft or a mass murder. And this may be difficult sometimes to accept. But again, think of the child who hits his parents or her parents, or think of the car driver who was hit by a storm or a thunder and hit a person walking aside who kills or who dies. So this doctrine actually reflects a very fundamental principle of justice seen from the criminal law perspective, that some mentally disordered offenders and some offenders generally should not be held accountable, that is unfair. So mental disorder then as an insanity excuse is a very problematic issue, and it's debated in many, many aspects. It is commonly, the world over, Norway included, associated with severe mental disorders, such as, most particularly, the psychosis disorders, such as typically schizophrenia, which is the most common disorder among those offenders that are found insane in the entire world. This is so. And which is also a common trait around the world is that the application of the insanity rule in legal practice depend on diagnostic categorization. That is typically the diagnosis criteria provided by the classification systems such as ICD-10 and DSM. So that means that in practice, the judgments are often, as part of the justifications, relying on forensic experts' diagnosis of what disorder this offender has. But at the same time, is the legal link between insanity and mental disorder unclear and contested. It is debated in many, many aspects. And to remember here is that people with mental disorder are especially vulnerable in the especially vulnerable population in the criminal justice system. They are not only those who are convicted for horrendous crimes, they are also those who are suspect or kept in pre-trial arrest or stigmatized by media and so on. The criminal law rule in Norway, I just want to show it as an example. It is also a clear example of how unclear criminal insanity rules may be. This is a new rule in Norway. We got it in October last year. For mental illness, it says that you are not accountable if you, due to a severe divergent state of mind, have a certain degree on failure of understanding of reality and a certain failure in functional ability. Basically, so what is a severe divergent state of mind? That is quite clear. From reading the preparatory work and the policy works, you could see that it's basically the condition of being psychotic, the state of psychosis, and some equally serious conditions. But also this rule opens for a wide discretion for the judge to actually assess in the individual case who should be understood as not accountable. We have not yet a case from the Supreme Court. I'm curiously waiting. This lack of clarity and these problematic issues should also be seen in the light of the significant consequences that these kind of rules have. Because criminal insanity judgments are decisive for choices about who is acquitted and who is punished. That is quite fundamental. It's a matter of whether you should go free on the street or whether you should be punished. And at the same time, commonly these decisions justifies time unlimited preventive commitment for those who are understood as insane in compulsory psychiatric institutions. You could, of course, on the other hand, say that they also justify access to mental health care and treatment. Because even though this access to mental health care is a human right, it is a difference in practice, whether you are sentenced to prison or whether you end up in a hospital. And of course, there is also the dimension of the public storytelling around this and the stigma that these cases are maybe can place on people living with mental illnesses. And remember that most people with severe mental disorders do never commit crimes. And most people in prison do not have these kinds of severe mental disorders. And this lack of clarity produces injustice. This is just one example from the local newspaper here in Bergen, saying that many mental disordered offenders are wrongly convicted. This is, of course, an argument that needs some more careful investigations, but it is surely so that there is a problematic variation, so that people with equally severe conditions are treated differently in the criminal justice system today. So this was just the background and our background motivation for now turning to the example of delusions. Just to start, and this will our medical expert Unn elaborate more about, but so that we know what we are talking about, or at least has a preliminary view, I can ask you, do you have a view on delusions? I mean, do you have an idea of what it is? Yeah, some are nodding, yes, that is great. And I was also, while I'm talking to you, saying that if you want to interrupt me or us while we are talking, we would very much love to have some discussion along the way. Otherwise, we will have time for discussion after. So, delusions, they are defined in this example, and this is not the only one, as we will come back to, in the ICD-10, which is the diagnostic classification system used in Norway. They are defined as incorrect convictions about oneself and or one's surroundings that are not compatible with reality and not shared by others, and that are uncorrectable. So you're basically strongly believes that something is true, such as you're threatened by an alien or followed by some strange Russian organization that wants to kill you and your family. And you strongly believe this, and you are not able to correct it. And it's not open to evidence, as we will come back to. Delusions is understood as a key psychosis symptom of what is often called impaired reality understanding. That you have an impaired ability actually to understand the reality in a correct way, or in the way that most other people do. This is, of course, a difficult question about how we should understand reality and who has actually the right to define how all of us should think of ourselves and the world. But this is a question that we'll not dig deeper into today. So, in any way, delusions is often an indicator of insanity in legal practice, you could say. It is often relevant aspect in insanity cases. And it's so because, and it's not, it is so because, of course, the interplay between forensic experts that diagnose defendants and that focus on their psychosis symptoms, and delusions are a key symptom of the most severe psychosis disorders, such as, for instance, schizophrenia and so on. From a legal perspective, it is relevant because it's considered to reduce or negate the ability to understand and reason about one's actions. So the idea is that if you're delusioned, say that, for instance, that you're delusioned about it, you're attacked by an alien, and therefore you defend yourself by hitting or killing that alien, which is in reality a human person. Then the criminal law idea is that you couldn't actually understand the reality, and you couldn't understand and reason correctly about what was right and wrong to do in this situation, because you were mistaken about the entire world. It is considered primarily to influence the motivations of a crime. And this is important because in criminal law, it is often discussed whether you did something with intent or not. So an intentional murder, so that you would actually, that was what you wanted to do, if we should put it very simple. And you understood that you killed someone, for instance, a human being. So in most cases with delusions, the idea is that the delusions are not affecting the intent on that level, but it's actually producing the morbid motivations for a crime, you could say. So it's actually the underlying motivation for that you commit a crime, such as the alien example, or that you're followed by the Russian organization who want to kill your family. The only thing you can do is to break into neighbor's house and hide yourself. So the motivation for doing this break-in to the house is produced by the delusion. That is the idea. I will give you some typical examples, and we will elaborate further on these from other disciplinary perspectives. So this is typical examples, and by typical I mean that typical examples when insanity is the conclusion. It is typical that you could read about delusions in the judgment. So this is one from Frostating Appeal Court in Norway in 2016. This was about a man who had committed serious criminal damage and violent crimes against his family. And he explained that he was constantly persecuted and threatened by the Albanian mafia, and that his actions were necessary protective measures. The forensic experts concluded that he had a persistent psychotic delusional disorder with delusions that affected his life substantially. And the court concluded that he was insane and sentenced him to compulsory psychiatric treatment. To note here is that what he was delusioned about could have been true. And we will come back to that. To note is also that it was said that he has delusion that affected his life substantially. It's like there is a degree, so that you could also have delusions that are not so, such as that your husband or wife are cheating on you or something like that, which could also be true. So the second example is from Oslo District Court in 2019, where a man had committed attempted murder against another man on a train to Oslo. He stabbed him 8 times with a knife. It was just a luck that he survived, because he got very quick to medical help and got the surgery. He explained to the police that he was innocent because he was forced by the devil to kill. And the forensic experts again could explain that he has massive delusions, and this time he was diagnosed with schizophrenia. The court again concluded that he was insane and sentenced him to compulsory psychiatric treatment. To note here is that these delusions, depending of course on what you believe in hell and heaven, are not considered to be possibly true. So they're of a more bizarre character. Again, it was a degree, and he was seriously affected by his delusions. So when talking about this, it's difficult not to mention the 2nd of July case. And this case is in many ways a special case, both in its magnitude and horrendousness, but also in the insanity evaluation. And in this case also illustrates a very difficult demarcation for the law, namely between psychotic delusions and extremist ideas. In this case, the experts disagreed as to whether the notions, this is a quote, herein described as psychotic delusions, or whether they must be understood as an expression of right-wing extremist point of view in combination with a grandiose and narcissistic personality. So what was at stake here, you could say, was what if one should take this in a storytelling perspective, which narrative should get priority? The narrative of the terrorist that was politically motivated, or the narrative of the mentally disordered perpetrator that was motivated by pathological and psychosis delusions? The court chosen the terrorist narrative. And it has done so also in latter cases, such as the Men's House cases, which is a Norwegian case. You see also from other, Christchurch, from New Zealand, or other countries. The court's assessment thus far, it says, is that the defendant's statement of being a participant in a civil war with expectation of a takeover of power in Europe can be understood in a political context that is significant in far-right extremist subcultures. Delusions are relevant in insanity cases worldwide. This is Andrea Yet, who found not guilty by reason of insanity in drowning her 5 children during a postpartum depression psychosis. We'll come back to this case and its specific philosophical and medical aspects. Because as you see, these questions, these problems and these cases are raising questions about what is really a delusion. How can we understand it? And if we can understand it, why can we say that delusions are relevant for criminal responsibility and agency? So the criminal lawyer, that is me, is obviously forced to consult other experts. So therefore, I would love to give the word to Unn. Please.
Yes. This image goes to show that the tradition for lawyers to consult psychiatrists is quite old. Law and psychiatry has been discussing this issue of criminal insanity for a very, very long time. So I'm going to say something about the medical perspectives on why delusions are relevant for criminal insanity. And as starting points, there are many different medical research perspectives, from the neurobiological approach, who would like to explain the human behavior by how neurotransmitters work in the brain, and the phenomenological approach, where you have a dissemination of the core self, and the cultural perspectives and the social cultural perspectives. There are many perspectives, and I obviously won't have time to discuss all of them. But as Linda touched upon, there are different types of delusions, ranging from those delusions of influence, where you are influenced by an external force that are completely bizarre and implausible, to the more plausible delusions, where you feel that you're threatened by mafia or the CIA or the PSD in Norway, which may be true. And then the distinction over to the extremist ideas. So delusions we see in several different medical conditions, such as schizophrenia, in bipolar disorders, in schizoaffective disorders, in delusional disorders, which all have kind of different severity, and also as depression with psychotic symptoms. So delusions are sort of multifaceted in a clinical perspective too. It's not like there's one solution to what a delusion is and why it's relevant to criminal insanity, and I will elaborate a little bit on that. But the most important point, and also dating back to the 22nd of July case that made this point really clear, is that there is a delusion continuum. I mean, we could all get, for instance, paranoid delusions is the best illustrative example. We could all get a little paranoid when we walk at home at night and we hear a sound behind us and we start to look, is there someone following me? And then that's sort of an evolutionary wise reaction to have. And then there is the delusion that the continuum that, okay, there is this person following me, and then there is this person following me because I am God, or I am some kind of, I have some specific abilities, and then there is this person, I have the possibility to make this person follow me. So there is a continuum from the almost plausible delusions to the extremely implausible, bizarre delusions. And also the delusions are multifaceted, and I will just like to read this statement to sort of that comprises how wide and difficult it is to capture exactly what a delusion is. And this is from the British Journal of Psychiatry, who challenged the researcher or a clinician to say, what is delusions? How can you say that in 100 words? And he answers, I once knew a person who believed he was the King of England. He asked others to book a limousine to take him to Buckingham Palace, stopping on the way to collect his benefits. He embodied different theories of delusions. Jasper's total alteration of reality, which is important, Bloiler's double bookkeeping, which is important, and breaking the rules of epistemic procedural and agential rationalities. Nevertheless, his humanity was a reminder that delusions do not happen in a vacuum. They are not abstractions discussed by professionals. They occur in real people. The delusions were phenomenological and understandable, but the person was understandable and a good man to know. And I think that's an important point when we discuss this criminal insanity and disorders and delusions, that these are persons. And there is a wide range of possibilities why people get delusional and how we should approach that. And as Linda said, one of for criminal law and the insanity problem, one of the most difficult demarcations or distinctions is between the extremist ideas or the extremely held beliefs. When do they turn into delusions? And when you have an extremist or an overvalued idea, then you are sort of extremely into that idea, but you may be talked into and convinced that this is not the case. But that's not possible if you have a delusion. And the 22nd of July case, it stirred a very wide international discussion that also launched the new concept of the extreme overvalued idea, which is even more rigidly held beliefs, but still it wasn't possible to fill the gap between the extremist or overvalued idea and the delusion. And this also is reflected in the clinics, where it's a challenge to correctly classify extreme and or idiosyncratic beliefs. When is something turning into something that, when is an idea or a concept delusional? This is something, I mean, it's been written a lot about in the 22nd of the July case. And as Professor Ingrid Melle from the University of Oslo was asked by the World Psychiatry Association to write about this, and she says, the main difference between the forensic expert report that evaluated the perpetrator as psychotic, that is criminally insane, and the one that evaluated him as non-psychotic, that is criminally sane, was that in the latter evaluation, the perpetrator appeared more open to alternative explanations concerning his own role, which made the reality testing regarding his grandiose notions appear less impaired. She does not take stand, and we are not to take stand in this case, but the core concept of reality testing is important to when an extremist idea becomes a delusion. So, how do delusions arise? The researchers are discussing how delusions arise, and this is also important to why delusions should excuse or not excuse in criminal cases. And there are two major mechanistic theories. One of the theories are that that people with delusions have high, they relate high aberrant salience to irrelevant events, and that the dopamine system plays a key role in this aberrant salience, meaning that you place too much value on unimportant information. This explanation does not provide an explanation of how the aberrant salience attribution leads to development of uncorrectable delusional beliefs. And then there is the second mechanistic theory, which is gaining support that errors in the interplay between prior beliefs, I mean, the way that we expect the world to be, and correction signals that correct our beliefs when our input does not match our prediction or prior beliefs. With this idea, with this theory, if you have too many incoming signals that are wrongly or not comparable with your prior beliefs, then you will get an uncertain understanding of how this world is, or the state of the world, and that could lead to formation of delusions. The world around you is so unstable, and you're not able to make this a comprehensive or understandable, completely, a complete idea of the world. But then, how do delusions persist if you have this mismatch between incoming signals and how you correct them? There is this second step that if you do have these disruptions, you could, if you do have this mismatch, there are also disruption in how you evaluate these incoming signals. And that is, people with delusions may be quick to jump to conclusion. They have this jumping to conclusion bias. And that's a tendency to make inferences based on limited evidence. And then if you have made those inferences and made those conclusions, they are not so available for corrections. And the neuroscientific community is really into trying to solve what's going on in the brain when you try to do these corrections of your incoming signals. And the image on the side goes to show that when you try to confirm or disconfirm your the error prediction inputs, then your visual areas are really distinguished between people with delusions and not people without delusions. And this neuroscience attempts to try to understand what goes on in the brain and how is that relevant for criminal insanity has been extremely important over the last 15 years. But still, it's a field that's evolving, but thus far without any good explanations. Another point that goes back to why we have all these different kinds of delusions that are differently related to violent offending. And as Linda showed, the idea of being persecuted is significantly related to violent offending. Also, the idea of being able to read other people's thoughts or being under control over a person or force. So there are a plethora of different delusions that we see in the clinic, but only a few of them are related to violent offending. So, and whether this should be important for criminal insanity evaluations is up for questions. And then Linda started to make the case of Andrea Yet, and it's sort of illustrative because the Andrea Yet case, she shows that Andrea Yet had not been a good mother to her children, she said. They were not developing correctly. She claimed to have been marked by Satan and that the only way to save her children from hell was to kill them. Then when the state punished her for their deaths, Satan himself would be destroyed. And television cartoon characters told her that she was a bad mother. She said she was not mentally ill and had never been depressed because she had never cried. So this example shows that the Andrea Yet case, there are different delusions working at place with the mark by Satan. She's acted like she is Satan, and she has to save her children from hell by killing them. And then she also has the double bookkeeping, getting back to Bloiler, where Satan himself will be destroyed when the state would punish, because she was aware that the good would be punished, but it wasn't Andrea Yet that was going to die, it was Satan who was going to die. And also the forensic psychiatrist who evaluated her said that she was rocking mutedly back and forth and had picked her scalp raw looking for a sign of the beast. That is, her conception of being Satan was not just semantic or an idea. It was followed by her actions and an extreme pain. So and she, but at this one time when she was still was aware of being Satan, she was still asking, when can I go to the death row? So she was sort of having this double. She was filled by her delusions, and she was also realistic about what her actions would lead to. And this makes the concept of criminal insanity very difficult, because while psychiatrists may say something about what is delusions, what is psychosis, what is impaired reality testing, our categories and do not always match the categories that are legally relevant or even philosophically relevant as to what should underpin what should underpin the decisions from the juries and from the judges and so on. And this sort of limits the role of psychiatry in these evaluations. And to further say something about what role the delusions and psychotic symptoms should play, we need some sort of a philosophical framework. And with that, I will give the word to Susanna.
Thank you.
Okay, so we will continue to discuss the same topic over again, but with a slightly different perspective. And I will start to get back to the backbone or the cornerstone of legal practices, and that is the notion of responsibility. I mean, this is the whole issue here, whether you are responsible for your actions when you have acted under the motivation of a delusion, or if you're not responsible. So yes, we hold people responsible for most of their actions. There are cases when we don't hold some, when we say that it's not my fault or something. And responsibility is the notion of responsibility is very important for our social practices as well as our legal practices, since it's a prerequisite for moral blame or praise. It's not just when you go to court, but also in everyday life, that, well, I'm in a position to blame you for doing this. Why did you show up? Why did you show up 1 hour after we set time to meet? I feel very annoyed and sad that you are disregarding me. And then the person that I'm supposed to meet said perhaps that it's not my fault. The bus broke down, blah, 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 blah. And I'm thinking, well, maybe she was not responsible for her actions, and then I'm not in a position to blame her. So we are in fair agreement, most of us, that it's not fair to blame or punish someone who is not responsible for their actions. And on the other hand, also praise the other, which we seldom discuss. I mean, that's the other side of the coin. And to be responsible, and this is something that actually goes back to Aristotle. So it's an old statement, but it still underlies our legal formulations of insanity in most countries. Norway is an exception. To be responsible, it is required that actions are performed willingly and knowingly. And willingly has been, I mean, what is it to act out of free will? It has, as you may have heard or understand, it's been something that has been discussed thoroughly by philosophers. And the different suggestions of what it could mean has been raised. One is that to have acted willingly is, I mean, you can say that then you were in a position to be able to choose another action, that you could have acted otherwise. Another way to frame that, which does not raise all the questions about free will and determinism, which I'm afraid we don't have time to go into now, is to say that the action was not forced or compelled. I mean, if someone is holding your hand, and using your hand to hit someone else, I mean, it's a very forced or compelled action. It may not be called an action, of course. But in the cases of delusions, this is very relevant, of course. I mean, we had the case where the Norwegian case where a person said that he was actually forced by the devil to kill. I mean, and then it is a question about, was he acting out of free will or willingly? A third way to try to define what acting willingly is to say that the action had its origin in the agent, that there is a connection to the agent's reasons and motivations. I mean, this is, of course, needs some time to go through, but basically it means that, well, if someone is doing something and you ask that person, why did you do this? And that person is able to come up with reasons for doing this and motivations, you say that, okay, so then it's an act of free will. But as you have seen in the cases we have been discussed with delusions, in this case, I mean, it seems like they were acting willingly. I mean, they had motivations and reasons. It was not that they were unconscious or something. And knowingly, which is what we have been discussed mostly here so far, is that, I mean, basically, yeah, to be responsible for your action means that you know what you're doing. I mean, and that could, of course, be elaborated on a lot. It could mean that, I mean, you know the nature of your act, you know, I mean, you know that you are actually using a gun towards someone instead of holding a banana in your hand. There is this famous delusion case, which is used in these circumstances, saying that someone who tried to strangle another person, when they asked that person who was trying to strangle, he said that I thought I was squeezing a lemon. And that was clearly a case where the person did not have any idea of what he was doing or the nature of the act. While, for instance, in the case of Andrea Yet that Unn was talking about, she knew what she was doing in one way. She was killing her 5 children. Yeah. So we could also talk about foreseeing the consequences of one's actions, that you need to, in order to act knowingly, you need to have some kind of understanding of what the consequences are of your actions. And this is, of course, difficult. I mean, in making a demarcation between acting from delusions and acting from ordinary beliefs, that, I mean, we are seldom in a position to be able to foresee all possible consequences, or yeah, maybe all possible consequences, but not the actual consequences of your actions. I mean, you do something and that in turn makes something else happen and so on. But it is required of us as moral beings that we do some calculation of what the most possible consequences are of our actions. That it's not a good idea to throw a glass in the direction of Linda because it might it might hurt her. That might be a consequence of that. So, and when we talk about the delusion cases again, we can see that, yeah, what did they know about their consequences? I will get back to that. And then the third part, to act knowingly, one might say that it also requires that you are able to do some kind of moral evaluation of whether it's the right thing to do. And that is what most of us do most of the time. And most of the time, I would say we're not really thinking about it. There are also a lot of morally irrelevant acts. I mean, where moral doesn't come into play. I mean, should I stand up or sit down giving the talk? It's not a moral question. It's another kind of question. But in some cases, we actually make moral deliberation. Well, is this the right thing to do? Should I tell this person that he has a stain on his shirt, or will that upset him, or is it a good yeah, you know, that kind of, what is the right thing to do? Okay, so then the question then, of course, how can delusions undermine responsibility? And of course, the delusions then may misguide a person, as we have seen, to believe things that are not true. And it could be things about the nature of the act. I mean, what you're actually doing. Are you jumping, or are you? The factual setting. I mean, the circumstances and the consequences of the act, and the moral evaluation of the act. I would just take a brief look at the examples. The first case that Linda was talking about was this man who hurt his family and said that he was persecuted and threatened by the Albanian mafia, and that his actions were necessary protective measures. So he knew what he was doing in this case, that he, as far as we know from the information we have here, I mean, that he was hurting his family. But the factual setting is not really clear whether I mean, from this, I mean, and this is something that is a problematic, of course, that we don't know enough in making these assessments. Did he think that his family was part of the Albanian mafia? Did he think that the Albanian mafia was there? Was he under immediate threat, and so on? We're in a position of not knowing all these things. We might say something about the moral evaluation of the act, that he thought that this was necessary protective reasons. And this is similar to I mean, some kind of self-defense, to say that, and that is something that is discussed a lot in courts when it comes to legal insanity cases, that if you think that you're under immediate threat of, say, an alien or the devil or the Albanian mafia, and they are about to kill you, and you strike out and with a knife or something and hurt the devil, if that were true, your actions would have been justified. I mean, it would have been an act of self-defense. If they were not true, which was the case, it was not self-defense, but as far as that person knew, he or she was acting in self-defense. And then the other case was a person who explained that he was innocent of stabbing because he was forced by the devil to kill. And I mentioned this earlier, that this might have more to do with the free will part than the knowledge part, that he was forced. But again, he didn't know, or I mean, there were a lot of things he didn't know. But maybe, I mean, the moral evaluation of the act again is relevant here, because, I mean, again, if you are forced by someone to do something, some of your I mean, the blameworthiness of your act is removed. I mean, you couldn't have done something else. I mean, so maybe in his own eyes, he was morally justified to do what he did since he was forced. And then the 22nd July case, I mean, this is interesting. The nature of the act, as far as we know, he knew exactly what he was doing. He was killing children. He knew where he was. I mean, the circumstances around it. What about the consequences? I mean, this is an interesting part. I mean, yes, in one way he understood the consequences, that all these people will die, but he also had a lot of other thoughts about the consequences, that this would somehow save Norway from a threat or something. And when it comes to the moral evaluation, he thought it was the right thing to do. But I mean, this is a clear case of where this discussion of moral evaluation becomes very problematic, because yes, he thought that what he did was right, but does that remove him of responsibility? Does that make him less blameworthy? It's not that, it could not be that someone who has a very deviant understanding of morality should go free just because of that. I mean, in my opinion, it's right to kill children, and therefore I do that. And then you're deluded, and then you should be free of responsibility. That doesn't, I mean, most people don't like that kind of reasoning. But this is something that is actually discussed a lot in the literature about insanity and in court cases, actually how to understand these. And to take the last example with Andrea Yet, again, she knew what she was doing. She knew that she was killing her children. She may not have a complete and accurate understanding of the consequences. She thought that if she didn't kill her children, they would be subjected to eternal damnation or something like that. I mean, she thought that she was saving her children by killing them. And when it comes to the morality, she thought, of course, that this was the right thing to do. I mean, there were different options, letting the children live and then suffer eternally in hell when they subsequently died, or kill them at this point. This was, I mean, yes, in the first trial, she was convicted, actually, of murder. And that was mostly because she knew what she was doing. I mean, she clearly had a criminal intent. And of course, it was such a, I think that the fact that it was such a horrendous crime played a role. I mean, we tend to, I mean, when we look at these high profile cases, there is a tendency to sentence those people that commit really, and when the media get involved and so on, we have the, and I'm not saying that that is the reason they are convicted, but there is such a tendency. However, in the Court of Appeal, she was found not guilty by reason of insanity instead. Okay, but to sum up this, I mean, there are a lot of questions here. I mean, when it comes to for the courts, I mean, to make a fair and accurate judgment of whether they knew what they were doing or not. And that is, I mean, crucial for the verdict of whether they are responsible or not responsible for their actions, and that in turn, whether they should be punished or not punished. And there are a lot of things that I would think, and Unn has said that is true. I mean, these people suffering from psychotic disorders, they are not just having delusions, they are disordered in a more global sense. So it's not very easy for them to explain exactly what their delusions are and what they thought about the consequences and the moral evaluation of the act and so on. So it's not easy for them to understand their own actions, and then of course it's not easy for the medical experts to say what they know, and it's not easy for the courts to make a ruling in these cases because there aren't enough knowledge. There is a knowledge gap. So then, I mean, there is a suggestion that perhaps we should not focus so much on the content of delusions, but the fact that people are deluded instead. And when we talk about, I mean, delusions, we think that they are beliefs. They are defined as beliefs in various medical manuals. And when we look at the ordinary beliefs we have, so they are generally supported by evidence, the beliefs we have. I mean, why do you believe this? It's because I read it there, and is that a good source? Yes, it's a good source because blah, 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 blah. And then someone says, I had recently read this study showing that, and you know, you're constantly re-evaluating your beliefs when it comes to new evidence. Then, of course, most of us are, when it comes to some beliefs, very firm and do not want to change them. And it's a continuum, like Unn said, from beliefs that we are very willing to change to beliefs that we are clearly unwilling to change, regardless of what people say. And then we come further on the continuum to what Unn called extreme overvalued ideas. When we are, I mean, there is hardly nothing that could make us change our minds. And then we have delusions. And delusions, and here we have yet another definition of delusions. Linda gave the definition from the ICD, which is a diagnostic manual. And this is from the DSM, which is another diagnostic manual. It's used in Sweden in forensic psychiatry, but not in general psychiatry. And here they say that delusions are fixed beliefs that are not amenable to change in light of conflicting evidence. The distinction between a delusion and a strongly held idea is sometimes difficult to make and depends in part on the degree of conviction with which the belief is held, despite clear or reasonable evidence regarding its veracity. So, I mean, maybe in judging these cases, we should not look so much or discuss what it is the person is deluded about, but instead how firmly they believe in their delusions. I mean, are they at all able to change their ideas? And this is, I believe, something that was discussed in the 22nd case. I mean, were these ideas extreme overvalued ideas or were they delusions? And there are different ways, of course, to judge that. But one is, I mean, how firm is the conviction in these ideas? And maybe that is a way to go. But again, I mean, from the court's point of view, it might be very difficult to judge whether someone is clearly delusional and in fact unable to change the beliefs, or if the person is not deluded, has some capacity, some rationality that makes it possible for that person to change, but the person is unwilling to change the ideas and is pretending to be delusional. So again, this is difficult whether whether this is the right thing to look at things in theory. It might be difficult to do it in practice when it comes to evidence. So then there is yet another way to look at delusions and legal insanity, and that is to view it as what is called a status excuse. To say that, I mean, basically, I mean, or not basically, that is what the Norwegian model is. It says it doesn't matter what you're deluded about and how firm you believe. It matters in somehow. But what means is that you are severely mentally disordered, and delusions are a sign that you are severely mentally disordered. So a person who has clear delusions about things clearly has had a complete breakdown of a lot of functions, which means that that person is not responsible for their actions, period. And that seems, I mean, easier to say, okay, we look at how sick does this person appear to be? And then we can say, this is not a person that could be responsible for any of the actions, or it could be a person that is responsible. But the problem is, why would we think that? I mean, why would we think that a severe mental disorder relieves someone of moral responsibility? Yeah, because we think that if you have a severely mental disorder, you're not able to understand the nature of your acts. You're not able to adjust your acts according to new knowledge. You're not able to change your beliefs. So it becomes kind of circular. I mean, you still have a basis for this idea, even though it might function in the courtroom. I mean, there is a theoretical underpinning that is exactly what we have been discussed previously. here, that there is something going on, which has to do with free will and knowledge, and has to do that we don't think that this person is responsible for their action, and therefore we think that the person should not be punished for their actions.
Okay, so now just a quick sum up. We just have one more slide. And that is because the question we will finally raise is whether we could reach an integrated perspective. What should we do with all this? And as you see, actually, we have just scratched a little bit on the surface. It's because we didn't want to keep you here for 10 hours, or we wanted to, but I guess you are not, did not want to. So, but we have maybe some very tentative conclusions as to sum up this. First, what we wanted to show by this is that the law in this field, and in many other fields actually, rely on assumptions that we need to explore in other disciplines. In this case, in criminal insanity, the law relies on medical as well as philosophical assumptions, as well as a lot of other assumptions that we have not dealt with today. We have also learned from Unn and Susanna that in these discourses that the law relates to, there are many different perspectives to the problems. The tricky thing is that the law has to provide binary answers. Are you guilty or are you not? Are you insane? Are you not? Should you get lifetime imprisonment? Should you go free? There are no maybe. We can try it out this week, but next week we try another thing. So, and this means that the choice of perspective, which of these assumptions or perspectives that the law chooses to rely on in the construction of the rules and in the legal judgments. Often this is happening, of course, not in these explicit ways, but if you read the rules carefully, you could identify and explore what perspectives they rely on to reach at the definitions that they work with. So which perspective they choose, the lawyers, us lawyers, may have significant consequences for how we define who is criminal insane and how we judge people who commit crimes, how we treat people with mental disorders. When do we start investigation? What do media write? And so on and so on. And as we have seen, there is a lack today in the law of sufficiently clear legal explanations. If you're really looking at the rules, we got confused about, but what is really this link between mental illness as some kind of medical category, what that is, and criminal insanity and responsibility? And what are the justifications for tying mental illness in the way the law currently does to mental illness as it is currently understood? And is it good? Or should we try to develop it further? And we also have now reached the conclusion at last that to reach these explanations, if possible, we need to explore the links between legal, medical, and philosophical premises further. So that may be our conclusion. And then I was actually also asked to say something about the project that we are working with. I should have done that in the beginning, but I chosen to do that in the end instead. So, because these questions that we have discussed relate to a larger research project, which we call the Dimensions Project. The full title or undertitle is Understanding the Relationship Between Criminal Insanity and Psychosis, Exploring Philosophical, Legal, and Medical Dimensions. So it goes into precisely this problem, but on a larger scale, and it has this funded by the Research Council of Norway with 12 million Norwegian crowns for a period of 5 years. It started up 1st June this year, and it will end until May 2026. It will include 3 postdoc projects. 2 of them are now 2 positions are they are hired and will start in October and come here. And in addition, it includes us, who are here, and a Professor Stephen Morris, who is in Pennsylvania. And we also have international advisors and collaborators. And hopefully we could, through this project, scratch a little bit also beyond the surface that we have talked today, and maybe contribute to knowledge development in this field. This is at least what we hope for. So this was everything that we would like to tell you. And now I hope that you have some questions and want to discuss this with us. So thank you so much for your attention.
Hi, thanks for all your explanation. Okay, for the reason of my profession, I have lived thousands of situations like that. Some very important, some criminal, and so other very normal or with no relevance. Okay, when there is someone with delusion, sometimes the police, the neighbors, their social network, and their family know them, know that this is happening. Okay, but in my country, only the family is who can ask to the judge that they have a brother, a father who have this mental disability, and can ask to the judge to make a doctoral, a medical revision, okay, in order to declare their legal incapacity, okay? But only the family can do that. And it's important because with this legal incapacity, if the family disappears, state can take care of this person, and also if they have children, they can take care of the children. But sometimes these people have no family, sometimes, and sometimes the family of these delusion people have not social skills to arrange this judicial process to declare their legal incapacity. And then when they are in this situation, no family or family with no the skills to arrange a judicial process, they finally are criminals or can commit a crime. And this is the worst option, and what we try to avoid as soon as possible. I noticed that the way in my country is that I don't know if here in Norway or in the Scandinavian countries you have more tools in order to detect this kind of delusion persons to not arrive to a criminal situation.
If I should start from the legal point of view, because this is a very, I think it's a good question. It's also a question that is discussed in Norway currently. But in Norway, just to start there, we don't have these structures as you describe where family can, but it's more of a matter of the relation between the civil or the administrative mental health care system, and whether you could first access help on voluntary basis, and then whether there are reasons for take compulsory measures. It seems like this is what you also are describing, that the family could ask for the court to judge that the state could take care of this person. So And we have this because in Norway it has become increasingly difficult to exercise or to undertake compulsory measures in the voluntary civil administrative system. And there is a discussion that the result of that is that many very mentally ill people are like walking around, and now I'm just lending the words of some, as like ticking bombs to commit criminality. And you have had these discussions some years ago that there are some like people and maybe defense lawyers, others that have their clients, and they are like in a way feeling that the only way to get true mental health care of this person is that the person commit a crime, because then we will have like the gate into compulsory psychiatric care through criminal justice system. So this is in Norway, I would say, discussed as a matter of the relation, what happens when, and we have the last years in Norway seen a very decline in the voluntary mental health care, and then could elaborate where we have a decline in the number of beds available. So it's much more of a like so it's more and more difficult to get actually mental health care and treatment if you're not very, very, very sick. And you could refuse treatment if you're not so a danger for yourself or others. So the gap in between with people that could have really need to have been taken care of and got help early, I think we have the same dilemma and the same problem. But here the problem is discussed more of a dilemma of, I mean, the principle is that people should not be, their freedom should be respected. So you should not risk being taken care of so it should be like a very high threshold for when the state could come in. But at the same time, when you have then a decline in the access of a voluntary mental health care system that is easily accessible. So I would say that is maybe the problem in not Norway, but in all countries, I think. Norway is a wealthy country, so we have still a lot of resources, but that we should also, here is my opinion, need a better like healthcare system for an easy access for those who want it early without having very severe problems and so on. So maybe, but this is a complicated, but from the legal point of view, yes, we have the same dilemma, and we don't have more structures to get into this control, so to say, maybe less, because we don't have this family thing. Yeah, option.
Yeah, I could just elaborate on that, because it's also like a practical medical. How do we arrange this problem if you have a delusional or psychotic family member? If I understand your question correctly, what are the ways into compulsory care or to get treatment? And we used to have a system where the family could ask for the patient to be taken into care, but it was too much of a burden on the families. So now it's just delegated to the head doctor of the city or the municipality to arrange for an involuntary doctor's appointment, where the doctor will decide if you need treatment in hospital, if you are so severely ill, this is before you commit a crime or anything, if you have like a sick family member. And then at that stage, the doctor has to ask if the person voluntarily wants to come to the hospital, then it's all good. But most patients with delusions don't really understand that they are ill, so they do not want, so you have to do like compulsory treatment. And then the law is that, like Linda said, if you are a danger to anyone or to yourself, an imminent danger to yourself or others, then you can get committed to compulsory care, involuntary care. But if you are not a danger to others, but you are in danger of declining your own health or not being able to get enhance your health, if the doctor judges that you are, or decides or evaluates that you are not competent to make decisions about your own health, then you can get into involuntary care. and before you commit a crime. So it's sort of, and that law was changed back a few years ago, and that, I think that is what Linda reflects. Before, you didn't have to decide or evaluate if the person had samtykkekompetanse or competency to make his own decisions. You could just commit anyone that you thought needed treatment, but now you have to evaluate that this person does not know his own best or is not able to decide what is best for his health. And then if you get the good treatment, and that is why, you know, what we hope to do in the psychiatric healthcare system, if you do get a good treatment, then you stop this, as you suggest, this derailment into criminal offenses and no societal boundaries or anything. So that's how it's organized in Norway. But as Linda also mentioned, the beds in the hospital systems are decreasing, and more of the beds are filled up with people who have been committed by law to involuntary psychiatric healthcare. So it's a dilemma, but it is a system to take care of the delusional or psychotic persons without involving the family, also those who do not have family, if the neighbors are worried or if someone is worried, police, and if anyone's worried about the person. If that answers your question.
Can I add something?
Well, okay then.
Are you? I come from Sweden and not Norway, and we have there is basically the same. You have said most of it, but I would just like to add one interesting historical fact is that if we go back to, I think, the 18th century in Sweden, it was really it's stated in the law that the family was responsible for whatever criminal acts the mentally disordered family member would commit. So then the responsibility was in advance relieved from the person and went on over to the family. And I think it looked basically the same in many countries. So then there was incentive really for. But then I would just add, this is discussed a lot in Sweden as well, and on the one hand, we have the basic human rights of freedom and integrity and so on, which means, just as Linda said, that the bars for compulsory measures should be really high. On the other hand, we have risk, of health risk, for the person herself, to be a risk for herself or a risk for others. One complication is that risk assessments for violence against others are very, very difficult to make. They are, in fact, just possible to make when someone has already committed a crime. All the risk assessment tools make use of the history of violence. And if someone has not yet been violent, it's quite difficult to judge whether this person will be violent. And then, of course, we are in a field of lack of knowledge. Should we commit this person and deprive this person of their human rights of liberty just because we believe that this person will be violent? On the other hand, if we are accurate and something really happens, so it's difficult. And in Sweden, I would just like to add, we have completely different systems for forensic psychiatric care and general psychiatric care. So again, it's the same that if you commit a crime, sometimes it happens that this is the first time a person with a long history of mental illness gets proper care, because then they come and the forensic psychiatric care has much better resources and then the general psychiatric care. So then, that might be a starting point for that person to get proper care.
Hi, my question is twofold. Initially, you mentioned access to justice, and so I wondered if psychiatric patients, you would consider them to have access to equitable and fair justice as it is right now? And the second part is, in your conclusions, we were alluding to the project that's coming and future either research or practical things that can be done. And I wonder to whom you're feeling as of now lies the obligation to drive us forward. Is it the legislature to legislate, or to drive a more active judiciary, of which we know that the judiciary does not like to be very active collectively? And so I wonder where you're sort of sitting as you begin the next venture into this. And yeah, maybe we'll see a development in common law or through legislation, and whether this will get us to access to equitable and sort of fair justice.
I can, since the first question is legal.
Yeah, and we have one question.
Yeah, the first question is I will try to give a brief answer, and I think the second one is personal also. So we have to. I cannot just talk for myself, so the other one has to say their stand. So the first one, okay. This must be, so if I should just give a brief short answer, the answer is no. I do not think that to date that people with mental illness have an equitable access to justice as everyone else. This is of course a complex matter, but basically I think that we're still, there are still stigma first around mental illness, to the extent that I think that it may be a hindrance also to be public, and that is one aspect, not for everyone, but for someone. I think that the fact that generally the criminal law and the legal system, in my view, unfortunately, is constructed by lawyers, and that means that it is sometimes that the people that are the most vulnerable groups and most in need to access the system has the most difficulties with it, because the language is tricky, the system is tricky, the bureaucracy around it is tricky. Just to know how to write a letter to the social services require like a 4-year education in law. Now I'm just okay. So that is my general opinion here, and I think that people with mental illness, and there is also the way of how do we, the society, think of people with mental illness. Do they treat them? Is there a bias? We have seen there are bias in like ethnical minorities and vulnerable group in general. So I think even though we have come much further today, I would say that no. In prison, there is a human right to access of mental health care. I think it's a difference between whether you got somatically seriously ill and whether you get mentally seriously ill. So no, the quick answer is no. I could elaborate this on another discussion. To the other way, who do we target in a way, ask, and what do we want to reach, and what is the motivation? The basic motivation underlying this project is that currently there is a lack of, there is no sufficient knowledge in the law, in the legal system, about mental illness, you could say. So, and to some extent, the criminal law is a traditional, and the legal system is by necessity traditional. So it cannot change from day to day. It traces back to very ancient ideas. So, and in this meeting between the law and psychiatry and also philosophy, but in particular between the law and medicine, I think that the law needs to be updated also in order to be able to communicate across disciplines. And so the underlying motivation is knowledge development and development of more fair and more knowledge-based standards for how we define and think of what we today call mental illness in this field. So that target in the long run. So it's more of a basic research project, you could say, but it targets practically legislators, but also, I mean, decision makers, people that are developing tool for assessing mentally ill people and so on. I think for me personally, and the core motivation is that I think that this stigma perspective, that I think that this link in particular, which is happening in legal practice between diagnostic categories and criminal responsibility and punishment is problematic, and we seek to reach beyond that by focusing rather on what specific deficits do the law actually care about, and is it correct to link with them to certain mental illnesses or not, and so on and so on. So it is a justice driven, and hopefully, yes, we could in some way, I am romantically idealistic, but I'm really realistic. So I think that hopefully we can contribute with some kind of enlightenment in some angle of this. But yes, I hope we could contribute to increasing justice. Would you like to?
The time is up, I think.
You have to say, do you agree with this motivation? I think we have.
Luckily, I agree with exactly what you said. So I don't need to add anything.
Yeah, for now it's good. I think we're out of time.
Unn does not agree then, but we will get back.
Yeah,
we have several years working on this, and I definitely also agree that the access to the legal justice system, I mean, people with psychiatric disorders have a really vulnerable position, which is something I actually have studied in a previous research project. So.
Okay, thank you so much for listening. And we are, since we will work with this in 5 years, and we are also collaborating with Law Transform and things. So hopefully and the door is always open and the email is there. And if you would like to discuss these matters with us, we are happy to do that. So thank you so much.
Thank you.